Hello and welcome to the Ottawa Business Journal's live broadcast of Termination, Preparation, and Offboarding, what employers need to know. I'm Michael Curran from the Ottawa Business Journal. Thank you for joining us here today. Since this is the first live broadcast from OBJ of the new year, let me wish all of you a very happy 2026. All the best to all of you. And if today's live event is any indication, business leaders are back at work, back at their desk, and enthusiastic to engage and expand their knowledge. In fact, today's live event has attracted the most pre-registrations we've seen in months, possibly years. Almost 400 business and HR leaders have pre-registered. Plus, we are live on YouTube and live on LinkedIn to reach an even bigger audience. Let me acknowledge right off the bat that this is a sensitive topic. Of course, we're talking about terminations today, and that isn't a happy topic for anyone, but I think it's a necessary part of business that is, for the most part, unavoidable. The other thought I have as we kick things off today is that terminations might be a very much discussed news item in 2026. And maybe that's the reason for so many pre-registrations. With continued economic uncertainty, disruption from AI, and the federal government's stated aim to shrink its workforce, 2026, to some extent in Ottawa, could be defined by terminations. So here's the question that we face today. How should employers prepare to offboard employees? And today, we're going to get into the do's and don'ts of termination. We'll be exploring performance management and documentation to prepare for potential terminations, key considerations for maintaining thorough records and ensuring compliance, and also conducting termination meetings with clarity, professionalism, and I'm going to add there, respect. All right, it's time to meet our guest. She is part of the legal team, legal experts at Emond Harnden LLP. Of course, Emond Harnden was established way back in 1987. It's the largest group of lawyers specialized in labor and employment law in the National Capital Region. She is a repeat guest, backed by popular demand, I like to say. And here is one of the newest partners at Emond Harnden LLP, Samara Belitzky. Hello, Samara.
Hi, Michael.
Well, you're starting 2026 off on the right foot. You're a newly named partner at Emond Harnden. Congratulations.
Thank you so much, and Happy New Year.
Yeah, lots of hard work went into that. This is, in fact, the second time you and I have talked about terminations. And, let's acknowledge again that this isn't an easy topic to talk about. It involves, sometimes a lot of emotions, a lot of stress, very kind of, if I could say, sensitive situations. We were going to talk about this, in fact, in December. We're going to do this, and we said, you know what? Let's wait until the new year. What are your big thoughts, kind of, on terminations and how people should be, starting to think about this a little bit, Samara, in 2026?
Sure. So as you said, this is a very sensitive topic, which is why we initially said maybe we don't want to be talking about this right before the holidays, because I can tell you that at least in my practice, I typically don't advise employers to let people go, right before the holidays or even right after the holidays. And it's a sensitive process, and sometimes a necessary process. And I think the most important thing is to remember that, we're all human. And sometimes in the business world, terminations of employment are necessary. It's kind of a necessary evil, if you will. But there are ways to do it that are respectful and that kind of limit the employer's potential legal liability while still maintaining that respect for the employment relationship.
Yeah, we'll probably get into it in the Q&A a little bit when we get a bit interactive with today's big audience. But in a sense, sometimes, in the best case, maybe I'll put it that way, Samara, that a termination is good for both parties, right? That the business has reached an end where it needs to end the relationship, and potentially it's best, maybe not immediately, but in hindsight, for the employee to say, you know what, that was for the best. I needed a new start too. Is that a fair thing to say?
I think it is, depending on the situation, right?
Yeah.
Because sometimes an employment relationship, just like any relationship, has run its course, right? And sometimes Somebody whose employment is terminated, they may initially be upset. It may be, it's a stressful experience for them. And there's always kind of a level of baseline stress that comes along with that. But oftentimes we see employees who move on to things that work out better for them, onto greener pastures, if you will. And so sometimes it can be a bit of a blessing in disguise for certain individuals. And it's hard to see at the moment, but later on it does come to fruition. And so I think that's correct for certain people. It's not
Yeah.
every situation,
No.
but I do think these things do have a way of kind of working themselves out for the
Yeah.
best.
That's really the best case scenario, which we all hope for, of course. We're going to look in our agenda here, and fully appreciating before I ask this question that your business, your practice is cloaked in lots of confidentiality and secrecy. Uh, but when you are talking to some of your colleagues, and hopefully you can answer this question at Emond Harnden, do you think 2026 will see an uptick in terminations, or it's hard to determine right now?
We're early in the year. I will say, based on what the trends that I'm seeing, it does seem like there are a lot of terminations kind of planned. I'm not saying they're imminent, but
No.
given some of the changes we've seen in the economy and certain
Yeah.
industries, I do think workforce reductions are unfortunately inevitable in certain industries and certain categories. And so I do think a lot of employers are trying to get ahead of these things, plan ahead, get all their ducks in a row, and so that they can proceed with, as you said, respect, because it is a sensitive process. But I do think we're in for some terminations, and whether there's more in 2026 than 2025, that remains to be seen.
Yeah, it's hard to say. All right. Well, that's the perfect segue because if you are watching this and your company or even you personally will need to be involved in this, you need to do so like all matters of HR law with precision and a little bit of brains and heart too. So here's the topics we have for today. Topic one, we're going to go over a lot of the basics to make sure people have the fundamentals down here, Samara. But the topic number one is performance management and documentation obligations. Important to note here that we're not saying everything should end in termination. There has to be a degree of performance management here. Topic number two is how to maintain records for potential termination. And then topic three, how to conduct a termination meeting if it gets to that. Sometime around 12:25, we'll be taking your questions. So whether you're on YouTube or LinkedIn, use the comment fields, and it all kind of comes to us right here. I hope there's lots of interaction. This is going to be a hot topic, but let's get right into this, Samara. Topic number one is performance management and documentation obligations. Take it away.
Right. So in terms of, terminations, we're talking about terminations today, but in order to do so from kind of a best practice perspective, I think it's important to take a step back and look at what can we do as part of the performance management or the management of the employment relationship, to best prepare for any potential terminations and make sure that the relationship is being managed accordingly. And so how do we do that? We look at performance management. And as kind of the old adage goes, the best defense is a good offense. And so moving forward in the employment relationship, you do want to make sure as an employer that you are documenting and performance managing. So that starts with, making sure that throughout the employment relationship, you're taking certain steps and implementing best practices. That doesn't mean you're necessarily going to terminate the employment of that employee. That employee may never be terminated. They may work for an employer for a very long time, but I think it's more so about taking the steps so that if it ever does go that way, you're prepared as an organization. And so rather than waiting until a decision is made to terminate somebody's employment, and then you start the planning and start thinking about the issues you might need to contend with, oftentimes it can be too late at that point for some of these issues. It's important to be proactive in trying to manage the relationship and document everything ahead of time. And that can help in many different ways, not just for terminations. I mean, we're talking about terminations today, but it does help with respect to maintaining a good employment relationship and a transparent one as well. And so, in terms of performance management, when we say performance management, we're often thinking about actual performance, right? Is an employee in carrying out their duties, are they meeting the expectations of their role? Are they meeting certain metrics? But for the purposes of today, and often when you are speaking with employment lawyers, when we say performance, it does encompass that, but it also encompasses misconduct, right? Potential misconduct in the workplace. The other thing that we would be looking at as well is attendance management, right? Absenteeism, attendance management, all of that kind of falls under the umbrella of performance and performance management. And so the first kind of point that you'll want to make sure that you're addressing is to make sure that the managers and supervisors are equipped to manage these issues as they arise, and that they're equipped and have knowledge of the best practice to document these issues accordingly. As an organization, some organizations have an HR department or an HR person. And so if you are an organization where you have those people, that should be done in conjunction with them, with HR. So the manager or the supervisor as applicable with HR. If as an organization there is no HR person, then the managers should really be aware of what are the best practices in order to performance manage and document accordingly. I'll also add that as an organization, you may also want to be checking in with an employment lawyer on some of these issues. And some of the more important issues we'll talk about in a moment, where you will for sure want to check in with an employment lawyer. Other times where maybe you don't have an HR person to consult with, that would be a good time to kind of check with an employment lawyer, get an opinion on certain performance management issues. Now, when we talk about performance management and the managers having kind of the obligation or giving the managers and supervisors the obligation to implement these practices, you'll want to make sure that managers and supervisors understand what the actual task at hand is, which is to document issues as they arise and to keep very clear records of these issues that can be referred back to later on. In terms of the purpose of this, and we'll circle back to this later on, but at the outset, when we're talking about performance management and making sure things are documented, what's very important is dealing with this concept of progressive discipline and providing employees with notice when they're not quite meeting expectations of their role, whether it's performance, whether it's misconduct, whether it's attendance. You'll want to make sure that employees are aware of where they may need to improve. And so it kind of works both ways, right? Employees need to understand where they may fall short, where they need to improve. And from an employer perspective, if you're doing that and being transparent with the employee and making sure they're aware of the issues and being notified in writing of those issues, it's difficult for the employee to later assert otherwise. And you're kind of protecting yourself as an employer as well. When we talk about progressive discipline or putting things in writing, often what we kind of assume is that it's to potentially terminate somebody's employment for cause later on. And that can be the case, right? When we're talking about termination for cause, and that's not one of the topics for today, but very briefly, the termination for cause is where an employee has engaged in very serious willful misconduct. And so absent a very extreme situation where an employee engages in one instance of misconduct, like, for example, theft or assault, where that one instance can justify a termination for cause, oftentimes we're dealing with a course of behavior, a course of misconduct or performance issues that eventually could lead to a termination for cause. And so in order to be able to justify a termination for cause, as an employer, you'll have to put progressive discipline in place. And oftentimes what I see is in a termination for cause situation, it may be that the employee has engaged in conduct that would justify a termination for cause. But as an employer, if you're missing that progressive discipline piece, maybe you've warned the employee kind of informally, but if you haven't put formal discipline in place and you haven't formally warned them, you may not be able to justify termination for cause. But more importantly, while it can help in a termination for cause, most terminations are without cause. And so progressive discipline and documentation is very helpful in that situation. It's more so helpful for situations for terminations without cause. And the main purpose for documenting and being on top of performance management in a contemporaneous manner is to make sure that as an employer, again, it's transparent with respect to the employees, but you're also protecting yourself in the event that the employee may later on bring forward allegations relating to their employment or relating to their termination. And some of those allegations could include things like, as an employer, you've engaged in bad faith in the manner of dismissal. The way that you let somebody go might have been embarrassing, might have been done in an untruthful manner. And so there's a bad faith component there that employees can allege. They can allege that there was a toxic workplace prior to their termination. And they can also allege, for example, that their termination, it wasn't related to performance, even though the employer is saying it's performance, it's because of a ground protected by human rights legislation. So an employee may say it's because of my disability or my age or my sexual orientation or my family. And so there are all sorts of, allegations that can come up post termination. That's when they tend to come up that we might not have predicted would come up prior to the termination. And so it's a bit of contingency planning so that if ever those things do come up, you're in a position to be able to deal with them.
There was a lot of details there. That was great, Samara. Two things popped to mind, maybe that I'll add. And of course, both of these are in termination without clause. A savvy HR person once told me, if you're going into a termination meeting with an employee and they're surprised, that's a failure of management. That's not there, because that suggests that management didn't hold up its responsibilities in clearly communicating things. And I think sometimes it's managing people is very complex and very difficult, and often we want to protect people's feelings and respect them, so it's tricky to give negative feedback, but you have to do that. If someone's not meeting the mark, it is not it is your responsibility, and it's for their betterment, if I could put it that way, that you need to be clear when people aren't meeting the mark, and be clear what that level of performance is, correct?
Yes, and I think it goes both ways, right? And sometimes I've dealt with this issue where the manager, the supervisor, like you said, feels bad. It can be uncomfortable. It can be awkward to give people negative feedback or discipline, right? But in the long run, it actually helps the employee and the employer, right?
Yeah.
So it cuts both ways. And you're right. I mean, I think in terms of a termination, sometimes people are surprised no matter what. I've seen situations where employees do receive warnings and they're still surprised. And so
Yeah.
I think as an employer, you have to expect that will happen sometimes. But if it is a performance related issue, you can manage that, and you give people warnings. Doesn't mean you have to, right? We're not talking about a legal obligation here. We're talking about best practices, which can then help you with legal issues in the long run.
And there will, to your point, be employees that sometimes are not self-aware. So this might be the fourth meeting you've had, and you've already had 3 meetings around performance. You've been very clear where they're not meeting the mark. You've made plans for them to change their performance and touch base. The other thing that you said there that just sparked a thought in my head is that maybe try to explore the why if you're in some of these. These are more HR stuff, by the way. These aren't employment law. But if there's a you don't want to terminate people and then have them disclose something. Oh, the reason why I wasn't performing was this. So if you're communicating that you're not meeting the mark, maybe explore the why a little bit. If for no other reason, that you're not surprised if it does lead in termination, that you're like, oh, I have a sick child at home, or I've got some sort of disability that I haven't disclosed to you. So it just underlines to me, Samara, that it needs to be an open two-way discussion, respectful, but within that business and employment law context.
Absolutely. And that kind of touches on the second topic. So I will be touching on that in a moment.
Okay. Let's go right now. And a reminder, we're coming to you in our audience. You'll get a chance in our interactive messaging here to ask some questions of Samara. But let's go to topic number 2: how to maintain records for potential termination.
Right. So in terms of best practices, we've talked about kind of the rationale and why as an employer you should, performance manage and keep records. So I wanted to give some kind of tips, some practical tips about how do we actually implement those things, right? It's nice to talk about, but how do we do it? And so generally speaking, for all meetings, you're going to want to have notes. And this is something that I know it's kind of a thorn in the side of many employers where you're so busy, the managers, the supervisors, everyone's so busy dealing with operational issues that sometimes we don't get around to documenting some of the HR or employment relationship issues. But oftentimes the failure to document those things can really come back and cause a problem for you later on. And so my kind of best practice recommendation is take notes, make them as detailed as possible, date them, sign them, make sure they're contemporaneous. And just a couple examples when we talk about, what kind of meetings should you take notes in. So one category would be meetings with employees, right? So if you're meeting with employees, it may be just an annual performance evaluation. It may be to provide them with a warning or discipline or kind of an informal warning about some of the issues that they need to improve on. Following those meetings, there should always be notes that are prepared. And again, as detailed as possible. Who attended the meeting? Who said what? Where did it take place? What time did it take place? These may seem like trivial details, but they can become important later on. And so you will want to document those things after the meeting. The other type of meeting that you'll want to document is internal meetings where you talk about an employee's performance issues or potentially talk about the decision-making process leading to a termination of employment. And so if you're having discussions about, Jane Smith is not meeting, the expectations of her role, we've talked to her about it a couple of times. At this point, it's really not working out. I think we might need to let her go. Those kinds of meetings should have notes created so that you can document that that's when you are having those discussions. A quick example of why you want to do that and where it may come in handy is there could be a situation where you decide to terminate somebody's employment or you start having those discussions, let's say in June. And then unbeknownst to that employee, of course, and then that employee, you don't get around to actually proceeding with the termination. And then in July, that employee goes on medical leave. And so as an employer, you don't terminate while they're on medical leave. You wait until they come back to work. And after they've returned to work, then you decide to terminate based on those performance issues that you experienced prior to the medical leave and the reasons that you made that decision way back then. In response, that employee is likely going to allege that the decision to terminate their employment was related to their disability or their medical leave. If you have contemporaneous notes from when that decision was made that show that it wasn't related in any way to that disability or medical leave, you then have something to push back with and to show that you actually acted in a lawful manner. Now, without those notes, you could still make that argument, you could still take that position, but it's a lot more difficult. And so that's, just to give you an example of why it can be important to document those meetings. Very quickly, in terms of maintaining the notes, if it's meeting notes with an employee, they should go in the personnel file. If it's internal notes, like the ones we just talked about, where you're talking about very confidential issues, like do we let somebody go and why, those should not go in the employee's personnel file. They should be kept in a separate, secure location. On discipline, if you are disciplining an employee, all discipline should be reduced to writing. So even if it's a verbal warning, when you go into a meeting with an employee where you give them a verbal warning, you should have a document that states that they're receiving a verbal warning, and you should give a copy of it to that employee. Everything needs to be documented. So even coming out of the verbal discipline meeting, again, you'll want to make notes about the meeting, and then you'll have that document that states that, so-and-so is given a verbal warning, which goes in their file. All discipline, all warnings need to be provided to the employee. So you'll want to make sure that the employee always receives a copy of any discipline-related documentation, and you'll also want to make sure you have proof of that receipt. So if it's in person, you'll want to have them sign, and for clarity, sign that they've received it, not sign that they agree, because I do think there's a lot of confusion on the employee side that when they receive a warning or discipline, they don't want to sign it because they think that means they're agreeing to it. So it's helpful, I find, to make it clear to them that they're not agreeing. They're just signing for confirmation of receipt. And often I'll suggest putting a line at the end to make that clear, to confirm receipt. You're not agreeing to it. It's not clear that you're agreeing to it. You're receiving it. That's if it's in person. By email, it's a little easier because if you send it virtually to their work email, they've received it. But very importantly, you need to have proof that they've received it, whether virtually or in person, in order for that discipline to be effective and to be able to use that discipline if it comes up later on. And to Michael's point about discipline, something that is very important is if you do find that you have an employee who is maybe acting differently than they usually would, maybe there's something going on at home, maybe there's a medical condition that hasn't been diagnosed. This does happen sometimes. As an employer, you will want to check in with them and provide them with the opportunity to disclose those things to you prior to going down the path of progressive discipline and then potentially a termination.
That's great. Very practical, by the way. So you really took those guidelines and really made them real world. We're going to keep rolling right into topic number 3 because we've got a bunch of questions piling up in the live Q&A. So keep on rolling. Topic number 3. So in some cases, right, Samara, you will have tried to manage performance. You've communicated clearly with them. You've made a plan for them to improve, but it's not working out. You're going to have to plan the termination meeting. Tell us how people should approach that.
Absolutely. So my recommendation in terms of any termination is any termination that's planned, check in with an employment lawyer. Do not proceed with the termination unless you're sure that you're proceeding in a lawful manner. Now, I know a lot of employers will not necessarily heed that advice, but that would be a best practice to make sure that you're kind of getting ahead of any issues, making sure you understand what are the employees' entitlements, what are they owed based on potentially a contract, what are they owed based on the Employment Standards Act or the Canada Labor Code if you're federally regulated. And so you want to make sure you're kind of planning accordingly, preparing a termination letter, getting all of those things organized in advance. In terms of the meeting, you'll want to hold the meeting in person if you can. And this is where I say if it's feasible, where applicable, because the guiding principle for the termination meeting should be making sure that it's as confidential and private as possible and the least embarrassing possible for the employee. So based on that guiding principle, that will help you as an employer determine, do we do this in person or do we do it virtually, right? If you have a very open workspace where lots of people would be around in person, maybe you do it virtually. If somebody works 100% remotely and they never come into the office, then it would be odd for them to come into the office for this meeting, and then you should probably keep it virtual. So there are different things that come into play depending on the situation, but that should be the guiding principle: is how do we preserve the privacy and kind of make this as not embarrassing for the employee. A best practice is to have 2 employer representatives present. It's not fatal if only one can be present, but you ideally want to have someone from HR and someone from management or operations, or if there's no HR, 2 people from management and operations. And in terms of the actual conducting the termination meeting, this is where, again, you'll want to be very mindful of making sure that you are proceeding in good faith. And so the reasons for the termination, this is where we've seen a lot of uptick in these types of allegations of bad faith. You have to be honest in the reasons for termination. And so I often see employers trying to kind of, you don't want to make someone feel bad and you don't want it to be personal. And so rather than say it's a problem with your performance, you may want to say something like, it's a restructuring, or we're eliminating the role because it takes kind of the personal issue out of it. But the challenge is the employee then can see that you've posted for that job the next day or the next week. They know you've not been honest in the termination meeting. And then that can actually lead to, number one, the employee then feeling badly, feeling lied to, feeling that you've made a misrepresentation. And also from a legal perspective can lead to a claim for bad faith damages because you haven't been honest and you haven't acted in good faith in the manner of dismissal. And courts are becoming more and more open to awarding damages, bad faith damages, for the manner of dismissal. So I don't say this to scare anybody, but you will want to be very careful in that regard and not misrepresent the reasons. And that's something that I workshop with employers a lot to make sure you're being honest, but we're softening it so it's not offensive or hopefully doesn't hurt anyone's feelings, but it's still honest. Something else that you can do to help you in that regard is have a script, have a termination script or speaking notes that you can follow along as an outline to make sure that you're not saying too much, you're not saying too little, you're just saying enough in order to make it a respectful meeting and then move on. In terms of the logistics, once you go through certain topics in the termination meeting, you walk through the reasons, you walk through what the employee will receive, what you might be offering them. The termination package or letter comes after. So it's a best practice to kind of discuss with them. And then if it's virtual, you send them an email with the package. If it's in person, you then hand it to them and make sure that they leave with it. You don't want to have anybody kind of signing anything on the spot and then later claiming that they were under duress or pressure. They should be taking it away with them. If it's virtual, you should be sending it to their personal email address. So the termination package should not go to their work email because you should have access to that cutoff, right? Any programs or accounts should be cut off, and it should be coincided with the actual timing of the termination meeting. So you'll want to confirm their personal email address, send that to them, and then back to the note taking. So following the termination meeting, and this is very important, you'll want to make sure whoever was in attendance prepares detailed contemporaneous notes of what took place, where did it take place, date, time of day, who was there, who said what happened after the meeting, was the employee, what did they say, they were walked out of the office, were they escorted? These are all things that could potentially become very important later on. And so you'll want to make sure you have very detailed notes. Again, you want to sign them, you want to date them, and have them be dated the day of the meeting. So that if anything ever comes out later on, if the employee ever asserts any sort of bad faith allegations later on, you have those notes from the date of the meeting that speak to what happened and that you can use to show that maybe you didn't do what the employee is saying, or maybe this didn't quite happen the way that they're alleging, because the bad faith allegations do tend to come up these days. And so it's very important to kind of protect yourself against that as an organization and document that meeting in case these issues do come up later on.
Well, that's great. Again, lots of information. We're going to go to our questions in a second. I just want to underline this, my personal opinion, that I'm a big believer in a script or notes and sticking to your notes. And as you indicated, Samara, you need to be honest, you need to be respectful. You want to share the reasons for the termination, but you don't want to share too much. Like there's that really gentle balance, right? So transparency, honesty, but don't start getting into some sort of debate or discussion because I've seen meetings go sideways. I always like shorter meetings too, not rushed, but shorter. But anyway, let's see what the audience has to say. First off, we want to give you congratulations on reaching partner there. So I wanted to. So the audience is rooting for you, and yes, the slides will be shared. So I know you don't get a heads up on these ones, but we'll see if you've got a response on this one. It might be a very specific situation. So Alex, I presume 6014 is saying any gotchas on term employment for specifically scoped projects. Is that might be super specific, but anything that pops to mind there?
I mean, I can speak to fixed term contracts, which is what they're asking about. Generally, I recommend avoiding fixed term contracts if you can, because the challenge with fixed term contracts is that if, let's say, you go past the deadline, then the contract's no longer enforceable. If there's an issue with the contract and its enforceability, and you try to terminate someone's employment before the end of the fixed term, you may be, as an employer, on the hook for the full balance of the
Yeah.
remainder of the contract. So it can become expensive in certain situations. And so I tend to avoid it if you can. If you can't avoid it, try to keep the contract 12 months or less.
Mm.
And not go more than 12 months. That's usually what I tell my clients who absolutely need to put a fixed term contract in place, is try to be on the lower end of a fixed term, and make sure that you are consulting with an employment lawyer so that your contracts are up to date and enforceable.
Yeah, that's good advice. Just minimize your exposure with a shorter
Mhm.
contract. Burkett Foster, who's often I see him at the mayor's breakfast and other events. I guess Burkett here is asking, this is in terms of record keeping, I presume, and what to track. So he's saying if there are activities expected, for example, a number of calls for a salesperson, can the phone records show that the expectation was not being met? So is there some data element that could be factored into your note taking, so to speak?
So I think, from an employer perspective, if you see that you have statistics or data that is showing someone might not be meeting the expectations of their role, you would have an obligation. If you wanted to discipline the employee for that, you'd have the obligation to take that information and kind of provide that to the employee and say, hey, we have this information here. It appears that you're not meeting this quota or this expectation. Um, what can you tell us about this? Is there
Yeah.
an issue here? And have that discussion. And then depending on how the employee responds, you may very well end up disciplining that employee or putting them on a performance improvement plan, right? But given that the data may not be absolutely conclusive, you would want to put that to the employee and give them the opportunity to address it first.
That's a great response. Check the data. Don't assume that it's 100% correct, especially if you've now spent months convincing yourself as the manager the person's not living up to expectations, and then you finally meet with them and they're like, "Oh yeah, yeah, no, there was 100 other calls that I didn't put into the CRM." Right? Like,
Right, or there was a glitch or whatever.
yeah,
Something, it may be very well that they're not working and they're not doing what
yeah,
they're supposed to, but
yeah.
they
Just
there may
ask.
be another explanation. And I would also add to address it sooner rather than later, right? Don't let it kind
Sure.
of fester for months and months and months. If you have that data or you have a suspicion about something, address it. Don't wait.
This one's more of a comment, and you kind of referred to it in some of your speaking notes. Been through a delay in termination due to illness. It was very
Mhm.
difficult to maintain working relationship during the waiting period. So it is. You know what? This might be more common. Than let's check in with you where someone's got a performance issue, you're starting to document it and think this might be heading to termination, and then boom, they're on short-term disability or something like that. Is that fairly frequent, Samara?
It does happen. Yeah,
Yeah.
it is something that we see and that we have to deal with. And oftentimes, you're from a legal perspective, our recommendation is always to refrain from terminating somebody when they're on medical leave, right? And
Yeah.
so sometimes that means you postpone your plans. And it is a delicate situation, which is why I always recommend in that kind of situation checking in with an employment lawyer, because even if, let's say, you made the decision to terminate before the leave, um, you know, whether you've documented it or not is a question, right? If it's not documented, you may have a problem from a discrimination perspective if you're going to terminate a week after they come back from their medical leave. So these are all the considerations that we have to look at in order to make sure that you're kind of proceeding in the best way possible.
Yeah. Well, yeah, just to reiterate what you said there a couple of times is, you better have notes. Right before you better be really specific and precise in your documentation before they went on leave. Jennifer Prevost, I was kept when you were addressing this one in the last the termination meeting topic, and I think you did say termination meetings can take place virtually. Like everything we're talking about, it depends on a whole bunch of factors. What you were making me realize, and I'm getting old. I've been in business for 30 years or so. So before virtual meetings, that is. So termination meetings at some point way back when were always in person. And
Mhm.
then the challenge, you again addressed it, Samara, is okay. Now this person needs to walk out of this office. People might have a sense of what just happened in the office, and we want to treat them with respect. And so virtually might be a good idea sometimes, right?
Yes, and that's why it's such a contextual analysis, right? And so it's the guiding principle of what's the least embarrassing? What do you think will go over best for this particular employee in these circumstances? Because yeah, I mean, some workplaces are not really set up for an employee to have privacy as they walk out. And so it may be that for that employee, a virtual meeting is better, right? And I didn't talk about this, but in terms of, retrieving personal belongings,
Yeah.
sometimes in the office setting, right? So I always recommend offering, you don't have to go back to your desk and collect your belongings. We'll ship them to you, right? You can just leave and we'll send them to you, right? And virtually that's what would happen too. We'll send you, your belongings. So sometimes those things can be less embarrassing.
Yeah.
And it depends. If you have an employee who you think is particularly emotional and will really not take it well,
Yeah.
then you may want to think about whether in person is better or worse, right? Depending on the situation. And as the employer, you would know your employee best, and sometimes that's what it comes down to.
Yeah. Thinking back to the 1990s and 2000s again, before virtual meetings, that was the worst part. Just having the person leave that termination meeting and they're emotional going back to their desk. People have a sense of what's happening. They're collecting their stuff. Maybe there's a flare up of emotions. I mean, it can be like, they can be volatile, right?
Mhm. Yeah,
Uh,
that's why I always recommend that they don't go back. Don't go
yeah,
back to make it as simple as possible. Or if they do need something for their desk, someone can get it for them and bring it to them. There's lots of things that can be done to
it's true.
try and prevent anything embarrassing.
Strong advice. I bet there's lots of people wondering about this, and of course, we've kind of touched on this in some past live broadcasts here. But any recommendations to proceed with time theft? So we're in this hybrid world or fully virtual world, and no one's quite certain. We have again full videos on this. But if it was a case of documented, time theft, what are your suggestions here?
So this is a bit of a doozy.
Okay.
Broad strokes, high level. If you do suspect somebody of committing time theft, best practices, you do have to carry out an investigation. So the investigation, if you want to terminate for cause. So if you do want to terminate somebody without cause because you suspect time theft, you certainly can, because you're going to provide them with their termination entitlements that they would otherwise receive. But if you do want to terminate for cause, meaning the employee doesn't receive any notice, any termination or severance pay, then you do have an obligation as an employer to carry out an investigation and give the opportunity to the employee to respond to the allegations. And then once those boxes are checked, assuming everything points to yes, they engaged in time theft, you would then be able to terminate for cause. That's generally speaking. Every situation is different. Sometimes it'll also depend on the length of service of the employee, because the longer an employee is with you, the higher that threshold for cause becomes
Mm,
in certain situations. So, for example, if you have like a 25-year employee and they've committed one act of misconduct in their entire tenure, that's something that courts will look at, right?
yeah.
I will say though, they do tend to come down pretty hard on theft.
Okay.
So that would be my advice for that
Okay.
situation.
We potentially could do a whole show on that one, but
We
listen,
could.
we're well into overtime, and apologies to a couple other people, but Sue Perron here is going to have the last question. And it's an interesting one. She's saying, does your documentation lose credibility if you don't do it contemporaneously? Excuse my pronunciation of that word. If you have notes in different places like calendar events, meeting records, and you compile it later. So does it have less credibility if it's not contemporaneous?
And it can have less credibility. So what I would say is you want to do it right away and you want to make sure it's dated. So even if, let's say, you have different things filed in different places, that's okay. But you want to make sure that your notes are dated,
Okay.
right? And that you do it right away, because the challenge is, let's say you don't do that. You then get kind of a demand letter or a claim that comes in making certain allegations. And then all of a sudden you have these notes, right? And so it can look a bit suspicious if the notes appear after you receive the allegation or the claim.
Yeah.
Whereas if they were prepared the day of the termination meeting and then you happen to get these types of allegations come in, well, you can show, look, here's our notes from the termination meeting. They're from that very day. And we actually address this point and it didn't happen the way that you're saying it did. It actually happened this way, right? So
Okay.
so that's where you'll have the strongest position possible if that ever does arise.
Okay. All right. As indicated, we're well into overtime. I kind of suspected we would have lots of questions, and it was the case. For our viewers, I just want to underline that you will get the slides, and you will get a replay link. So one of the things that is really important and a reason for you to pre-register for these. So let's go into our takeaways. Samara, we'll bring them up on screen, and you can wrap things up for us.
Yep. So again, at the risk of kind of sounding like a broken record, make sure you're addressing performance issues, making inquiries with employees, dealing with these issues in a contemporaneous manner, dealing with them immediately, not letting them fester, making sure that discipline is provided to the employee receives copies, you have evidence of receipt of those items, of those warnings. Make sure that you're taking very clear, detailed notes of any meetings relating to performance or discipline or potential terminations. And then, of course, make sure leading up to the termination and during the meeting that you're conducting the meeting in accordance with the law and in good faith, because as I mentioned, the good faith issue has been coming up a lot more recently. And so you'll want to make sure that you're being, as you normally would, be respectful and honest because you want to treat employees well. But for legal reasons as well, it's even more important to make sure that you're conducting yourselves that way now more than ever. And consult with an HR consultant or an employment lawyer prior to taking any steps to terminate somebody's employment so that you can make sure that you're kind of following all the steps from a legal perspective and a best practice perspective to try to reduce any of these issues coming up post-termination.
Yeah, it's great advice again. Samara, we're going to bring up your contact information. Again, this will be shared with everyone who pre-registered. Let's bring that on. So there you go. Samara Belitzky. Of course, it's Emond Harnden. So you can look her up on the website as well. But there's a phone number and an email. So thank you, Samara. We appreciate this. It's not an easy topic, but I think you did so, with a lot of high-level principles, practicality, and I think there was an underlying tone in how we approach this that, all these matters need to be approached with respect and with the employee's privacy in mind. So thank you for doing such a great job again. We really appreciate it.
Absolutely. Thank you for having me, Michael.
Okay. Hope to see you soon. Maybe we'll do something on time theft. We'll bring that back to the powers that be at Emond Harnden. All right. There's Samara Belitzky. See you soon. And a reminder for the audience as we wrap up that if you're someone who likes to stay on top of local business news, you should visit our website, obj.ca. It's updated several times a day with unique web exclusive content. It's a big year for 2026. It is OBJ's 30th anniversary. And that means a few things. That means we are just about to go to press with a beautiful new glossy magazine format. And let me tell you a little bit more. For 30 years, OBJ has printed a tabloid newsprint format. We are permanently switching 5 times a year to a beautiful glossy magazine that will debut in February with our fastest growing companies feature, as well as a anniversary feature. So if you're curious about the behind the scenes at OBJ, you can check that out. Also, we're naming the top 30 business stories of the past 30 years. So that's kind of a cool thing to do. Of course, we appreciate that this is a digital world. So we're focused on the glossy magazine. We're also making some really interesting website changes to our article pages, to our homepage. And we're finalizing plans for a smartphone app later in 2026. I highly recommend that you subscribe to OBJ Today. That's our weekday email newsletter. You can follow OBJ on social media. I recommend LinkedIn. And finally, if you're watching this on YouTube, click the red subscribe button and then the little bell icon. If you do that, you get a pop-up on your smartphone when we are live. Thanks for watching. I hope to see you real soon. Take care, everyone. Happy 2026. Bye-bye.